Welcome back, y'all. I am the loud little ducky. Today we are going to be going over Owens' Addendum for her pretrial statements. She has added on to what we have already gone over. So let's see what else she and Gingras have to say. Gingras files this in the Maricopa County Superior Court in the state of Arizona in the matter of Owens V Echard, addendum to petitioner's pretrial statements assigned to the Honorable Judge Matta. Gingras states, pursuant to Rule 76.1 Arizona Rules of Family Law and Procedures, petitioner Laura Owens, Laura or petitioner hereby submit the following addendum to her pretrial statement. This addendum addresses issues required by 76.1 G, contested issues of fact/law, and 76.1 G13, exhibits and objection. To the extent necessary, Laura also moves the court to admit late disclosed evidence pursuant to 76.1I as disclosed below. Specifically, as the court will recall, on April 30th, 2024, Laura filed an emergency motion to strike and request for immediate telephonic scheduling conference. We have gone over that. That is in the Bachelor Uncovers the Truth. That pleading explained that earlier that same day, April 30th, 2024, respondent Clayton Echard disclosed for the first time documents purporting to show Laura sent fake medical records to ex-boyfriend named Michael Maraschini in 2016. The motion to strike further explained Mr. Echard's motion is supported by dozens of pages of new documents which he only disclosed for the first time today, April 30th, 2024. On May 2nd, 2024, Clayton filed a response opposing Laura's emergency motion to strike. In his response, Clayton claimed the medical records he disclosed on April 30th, 2024, the ones allegedly sent by Laura to Mr. Maraschini, were not new because he claimed the records are her medical records and therefore not new to Laura. OPP at 2 through 6. The next day, May 3rd, 2024, Laura submitted a reply in support of her emergency motion to strike. Laura also filed an affidavit in which she attested unequivocally that the medical records attached to Clayton's April 30th, 2024 7th supplemental disclosure statement were fake. These are not my medical records. Laura further attested, I have no idea who created the fake records attached hereto as Exhibit A. All I can say is that I did not create them. I have no idea who did. I never sent them to anyone else. Never sent them to anyone else or anyone. Just herself. Never sent them to anyone else. Does that mean you created them? That sentence is weird. Because I had never seen these documents prior to them being disclosed by Mr. Echard on April 30th, 2024. Laura's affidavit from May 3rd, 2024 at paragraph 6. Days later, on May 7th, 2024, just 3 days prior to the close of discovery, Clayton disclosed an additional 2,489 pages of documents which he claimed were copies of text messages sent between Laura and Mr. Maraschini in 2016 and 2017. In effect, this data dump purported to show the full and complete exchange of text messages between Laura and Mr. Maraschini, as opposed to the partial snippets disclosed on April 30th. And sure enough, in this claim were the same fake records attached to Clayton's April 30th, 24 disclosure statement. One example is shown here with the bait stamp. That is the one medical record. And then the iMessage is, I'm sorry, I will be better at being a teammate. This creates an obvious concern. Either Laura lied in her affidavit when she said she did not create this fake ovarian cancer document, air quotes, or Clayton, or someone on his team lied about the authenticity of the text messages purportedly found on Mr. Maraschini's computer. Are you saying that Woodnick or Mr. John Berryhill lied? I don't know that Berryhill is willing to put his reputation on the line for this, but okay. And those people are not known for their arts and crafts of documents. So probably the scenario is Laura lied. That shouldn't be a shock to you, Gingras, because she has lied so many times before. She just has fessed up before. So this one, she hasn't fessed up to yet. To help provide more context, attached hereto as Exhibit A are 2 pages from the report of Clayton's expert, John Berryhill. These 2 pages show the ovarian cancer thumbnail, the next message below reading, "I'm sorry, I will be better at being a teammate," and the prior messages above it, which ends with, "We need to try to be teammates." So it says, "I messaged my doctor and I already got a response. You promised that you would be supportive. Once I sent you what you asked for, and this is above and beyond. So can you please take back what you said and move forward? Not asking you to act like nothing bad has happened, but I am sure I don't need the silent treatment right now with all that's going on. We need to try to be teammates." And then he says, "I'm sorry, I will be better at being a teammate." Again, if the documents disclosed by Clayton are genuine and authentic, they appear to show Laura did send the fake ovarian cancer document to Mr. Maraschini, and that she lied about this fact in her May 2nd, 2024 affidavit. Well, that is probably what happened, because she sent a picture of herself too. Was that faked? Because we have that picture. I've used it. For context, the screenshot above purports to show a text message in a blue box which reads, "I'm sorry, I will be better at being a teammate." Above the blue box is some text which appears to represent metadata regarding the message, i.e. information showing the date, time, and sender/recipient of the message. Directly above the metadata is an image with a file name, full-size render 1 JPEG. In the 2,500-page document disclosure by Clayton, this image is essentially illegible. It cannot be clicked on or otherwise expanded for a clearer view, and the text is too small to read. However, it appears this small thumbnail image is probably the same as a larger version that was attached to Clayton's April 30th, 2024 7th Supplemental Disclosure Statement, Bates number, shown here, which we have gone over. This ovarian cancer note, this one is from Sutter Health, not One Medical. So my apologies when I said One Medical. And this is from John Chung Kai Chan. And it says, "To Laura Owens from Dr. Chan, 8/13/2016, in regards to ovarian cancer, Owens. Dear Laura, thank you for your email. I'm sorry you are going through such a rough time right now, and will do my best to help you through it. I read the messages you sent me from your boyfriend and answer his questions. Stage 1A is without a doubt considered to be true cancer and something that we take very seriously. You are correct, Laura, that this cancer is found in one ovary. He is incorrect in saying that this means you just might have malignant cancer cells. Please tell him that yes, I have diagnosed you with real ovarian cancer, not something that just may be there. I'm not sure what it meant by the message you forwarded that says I would only be diagnosing if it was something other than stage 1A. This is a very real stage and simply means it has not spread beyond your right ovary. I recommend looking at the American Cancer Society's webpage for more information. I don't know if a doctor would say, please go look at the American Cancer Society's website. I think the doctor would have given her information about what's going on. Usually they send you with information. They don't tell you to go to an American Cancer Society's website. Nothing against the American Cancer Society. They're a wonderful organization. But I don't think the doctor's telling you to go there for your information. They're going to give you the information as a doctor themselves. They also don't care what your boyfriend has to say. They may talk to you about it in your appointment if you say, oh yeah, my boyfriend thinks this, and they may say something but usually they just ignore that and just stick with the facts. And who's known to message, and why are you sending your doctor your personal text messages between you and your boyfriend? That's crazy. She just messages anybody and everybody. She just spends all day on email. In addition, you can let him know that your diagnosis and treatment has been complicated by your pregnancy. So she has somebody else that talks about the pregnancy, which on its own has been extremely difficult and unusual. How would her oncology doctor know whether her pregnancy has been complicated or not? He doesn't know that as a matter of anything. He's not treating her for pregnancy. He would never say this. I would strongly encourage him to change his attitude and support you at this time. I sincerely hope things get better. They would never tell somebody that they need to change their attitude. They would be like, I hope you have a good support team. If he's not that person, then at least you have your mom and your sister and your dad. They're not going to be like, oh, they should change their attitude. Especially a guy. Do you see a guy really saying, well, he needs to change his attitude? A guy's not going to say that. Maybe a girl, but I still don't think that they would say that. The specific ovarian cancer message is one of the documents Laura referenced in her May 2nd, 2024 affidavit she denied creating or sending to Mr. Maricini. Yeah, I bet she did. Dr. Chan is he specializes in surgical and medical treatment of ovarian and other pelvic cancers. He is certified in gynecological stuff as well. He is an obstetrician as well. So, yeah, poor man gets looped into her BS. Gingras goes on to say, however, Laura maintains that she has not lied. Okay, we're supposed to just take her at her word? No. In fact, in the course of preparing for trial in this matter, literally yesterday, June 6th, Laura discovered a screenshot of the original teammate's text message exchange with Mr. Maricini. And guess what? The fake ovarian cancer document does not appear in the original message thread. Nobody cares about a screenshot. They can't be trusted with her. She can delete something. She can make it appear however she wants to in the screenshot. That's not the original message thread. That's a screenshot of a message thread. Doesn't prove anything. We know she likes to do her arts and crafts. She could have deleted something. Also, does she have screen grabs of the before conversations? Or has she deleted all of that stuff too before she's taken screenshots? Because I'd like to see that. And I thought she didn't have her phone anymore. Did she get this off the cloud? Because she didn't get it off of her phone because she said she didn't have it anymore. I'm not buying this, and the fact that you do, Gingras, is ridiculous. The problem here is obvious. Either the 2,500-page document produced by Clayton's expert, footnote 1, Clayton's expert John Berryhill may certainly qualify as an expert in certain areas. However, Mr. Berryhill does not appear to be offering any expert opinions. What? Okay, I'm pretty sure he did offer his expert opinion. He talked about this computer hasn't been touched since 2017. It hasn't connected to Wi-Fi. It hasn't had any updates. Nothing. But okay, go off. Mr. Berryhill does not appear to be offering expert opinions. Rather, he is just testifying about information he claims to have found on Mr. Marachini's laptop. As such, Mr. Berryhill is not offering any expert opinions under Rule 702 of the Rules of Evidence. Rather, he is offering testimony as a normal percipient, fact witness based on his alleged personal knowledge of the matters he observed. Sir, do you know what metadata is, Gingras? Do you know what metadata proves and why it's used in criminal cases and so forth? It's because it can be trusted over people's screenshots. But you know everything, right, Gingras? John Berryhill knows nothing. He hasn't been doing this for years. Why don't you stay in your own lane, Gingras? You don't know what you're talking about. Clayton's is not authentic or Laura's testimony and the above screenshot are not true. Yeah, I'm voting for that one. One party is telling the truth, the other is not. The question is who is lying. That would be your client who has lied at every avenue she can. Resolving this factual dispute is the job for the finder of fact, this court. But under a correction application of Rules of Evidence, Clayton's 2,500-page document is clearly inadmissible in this proceeding. I don't think so. This conclusion is based on the classic best evidence rule as found in Arizona Rules of Evidence 1002, which provides an original writing, recording, photograph, or video is required in order to prove its content, unless these rules or an applicable statute provides otherwise. Well, your screenshot is not an authentic thing either. The authentic thing would be the message from the messaging system, which I think the metadata provides. To be sure, the very next rule of evidence, Rule 1003, does provide otherwise. The rule allows copies, duplicates to be admitted except when there is a genuine question about original's authenticity. A duplicate is admissible to the same extent as the original unless a genuine question is raised about the original's authenticity or the circumstance make it unfair to admit the duplicate. Emphasis added. Here, there is clearly a genuine question regarding the original's authenticity. Indeed, the original computer files used to create the 2,500-page PDF document attached to Mr. Berryhill's report have never been disclosed, not even to this day. They tried to tell you about it. You chose not to send it to somebody because you said sending it to a forensic expert yourself was probably going to reach the same conclusion. You chose not to go that route. That is on you. The only disclosure is a report which Mr. Berryhill claims contains copies of text messages found on Mr. Marachini's laptop. But the laptop itself has never been disclosed, nor has the original iMessage data file containing the text messages themselves. Furthermore, the circumstances of this disclosure could not be more patently unfair, rather than disclosing information in a timely manner as required by Rule 49. Clayton waived until 3 days before the close of discovery to dump this massive amount of data on Laura. It was still within the discovery, so it doesn't matter if it was 3 days or 1 day before. It was given to you before the disclosure deadline. Quit throwing your fits because you have a client that can't quit lying. You chose to represent her. Perhaps in other circumstances, Gingras goes on to ramble, these concerns would not be so substantial. But in this case, there is a very real concern about trusting evidence from either party. Bullshit. No. The only evidence that hasn't been able to be trusted is Laura's evidence. Clayton hasn't submitted anything that is not trustworthy. And if you want to go by lawyers' statements, that's not Clayton. That would be Woodnick saying things. But Clayton is trustworthy. He has done nothing to show that he is not, except for not file some stupid real estate properties which he has dealt with the consequences of. She can get over herself. But let's go on. Laura has openly admitted to editing at least 2 documents, a sonogram from Planned Parenthood and an HCG test from Any Lab Test Now, neither of which were ever used as genuine evidence in this case or any other court proceeding. You are wrong there. The HCG test has been talked about. But no, Laura didn't submit that to the court. She submitted the fraudulent one to media and Dave Neal and Reality Steve. The sonogram from Planned Parenthood, she has used it in court proceedings. I don't care what she says. That's that whole October time period that you seem to forget about, Gingras. It's very much in this case. There's been HIPAA releases about it in this case. It was used. There was also sonogram images used in the protection order case. But the Planned Parenthood one is very much a part of this case. So I don't know where you're getting that it has nothing to do with this court proceeding or any other, because it does. Although she maintains the documents are immaterial to any issues in this case, well, she can think whatever she wants to think. Her noggin ain't exactly right. Other than her credibility. Yeah, which she has none. If you ever watched Step Be Heard, you would know that credibility in that civil case was a huge thing. And when you have no evidence backing up the drama and words coming out your mouth, you are deemed a liar and uncredible. And the other person has stuff that backs up their story. Credibility is huge in civil cases. They're somewhat big in criminal cases too. Your credibility is a lot. And your client has none. I noticed that's where you end that paragraph and you do not go on to describe anything that Clayton has messed up in this case. You can say at the same time, as this court will learn at trial, there is clear and compelling evidence that Clayton has made false statements to Laura. Whatever, that's about the stupid real estate. Did you tell her? Said I told her. Yeah, okay, he told her. He didn't make those to the court. He didn't lie to the court. He lied to her. So, no, the evidence and stuff in this case has been trustworthy. Him making statements to her the day after they had their rendezvous is not making false statements to the court. And then you would say, oh, more concerning, there is clear evidence that Clayton's counsel has knowingly made false material misrepresentations to this court in pleadings filed in this case. Okay, one small little thing where he said it was as big as her hand or bigger than her hand when it was actually supposed to be smaller than her hand. He corrected it in the following document. She also used her hands to gesture the size of it. So, like one little misrepresentation. That's not even a little minor perjury, what your client has done, though. But okay, yeah, let's act like Laura and her doctoring of documents and lying and perjury and creating false people and everything is on the same level as making a mistaken representation about a smaller than a hand or the size of your hand. Like, those are not on the same playing field. Get over yourself, Gingras. False statement court pleadings filed in this case. Ugh. For those reasons, the court cannot assume the veracity of the 2,500-page PDF report produced by Clayton. Only the original computer files will suffice. Indeed, the PDF itself was produced in its entirely insecure manner, i.e. the PDF was not locked or protected against modifications, which could and should easily have been done. In plain English, this means anyone with common PDF software can open the document and change the contents, like the example shown here, created by undersigned counsel. Well, I'm glad you know how to do that. Because he probably just had it in that, and it didn't, like, I don't know if everything that I don't really create PDFs, or I may save a file as a PDF or open PDFs, but not everybody locks it or unlocks it or puts a passcode on it. Like, some people just have PDFs as PDFs. So I don't think that's that big of a deal. Maybe it is. I don't know if you have to do something to make it unlocked. But your client is the one that likes to mess with PDF and Adobe. But I'm glad you and your client both know how to fake things. Because he wrote, someone faked this. And that's how he tagged the file name. And then he put the temp in Phoenix was 110 on June 6, 2024 as the text message instead of the teammate thing. Example, non-original shown below. Like, you really did something there. Because the contents of the PDF can be changed by anyone at any time, and because the original data files used to create the PDF were never produced, this means the exhibit is inadmissible, pursuant to the best evidence rule 1002. To be clear, this objection was raised in Laura's original pretrial statement. The only addendum here is the screenshot of a recently discovered text message that is inconsistent with the version produced by Clayton. Well, it's amazing that Laura can go and find these things that people have been asking for years. She just has all this stuff saved. Why does she have a screenshot of that anyways? Like, why would you need a screenshot of that text? Like, that's not an important text to me. Oh, look, he said we need to be teammates now. What? Like, does anybody else just screenshot texts all the time just for the hell of it? No. Like, if you have something that's funny or you're like, oh, here's what this person said, like, you might send it over. But, like, for the most part, we're not just, like, screenshotting and saving this and building a case. You might save your texts. Like, people with baby daddies, so, or, you know, like an ex or something. So if you have to go to court, you have all the text messages saved. That way you can pull them up and stuff if anybody needs to see anything. But we're not over here just screenshotting a bunch of shit. Granted, you might have had to back in the iPhone 6 days, but I don't think so. I know there was a time where, like, if it was still in there, unless you put it to save the messages over 30 days, that, like, sometimes your messages would delete after 30 days. But I think there was a setting where you could have them not delete, but I don't remember, and I'm not a phone tech person. Addendum is a screenshot recently discovered text messages that is inconsistent with the version produced by Clayton. The version produced by Clayton's counsel via Michael Maraschini. In short, the veracity of contents of the PDF produced by Mr. Berryhill depend entirely and solely on trusting that Mr. Berryhill, Clayton, and his counsel did nothing to tamper with the document. The rules of evidence and basic common sense do not permit such an important issue to be based entirely on one party or lawyer saying, "Trust me, Judge, you can take my word for it. Just don't fact check me." No, that's what Laura wants. Laura does not want to be fact checked. Maraschini, Gillespie, I'm sure Matt, and Clayton, you can check my facts. You can look at anything and everything you want. Because I'm not the liar in this scenario. She is. I don't think any of these men would matter. Like, go ahead, check them. Because they have nothing to hide. Your client has a lot to hide. She has many snakes in her closet. Or under her bed, or in her boot, or whatever the saying is. Skeletons in the closet, not snakes in the closet. Oh my God. Excuse me, blonde moment. For the reasons stated above, Laura hereby supplements her previous objections to the admission of any part of the 2,500-page PDF attachment to Mr. Berryhill's report. This includes, but is not limited to, an objection to Clayton's Trial Exhibit 48, any testimony regarding the context of those messages, and any exhibits purporting to be used based on the information obtained from Mr. Maraschini's laptop, dated June 7th, 2024, signed by David Gingras, copies sent to the correct people. Also, if Michael Maraschini didn't want to be fact-checked, why would he hand his computer over to a forensic expert? That forensic expert could have disagreed. We could have gotten that report and said, yeah, I can't tell if any of this stuff has been messed with or not messed with. The way it's saved or the way it was backed up, I can't tell anything. But that's not what came out of that forensic report. He went to one person. You went to no people. He was willing to put his laptop on the line and say, somebody verify me. I'm sending this to an expert, so it's not just a he said, she said. I'm going to have somebody back me up who knows how to look at this stuff. And all we have is Laura and fake screenshots and doctored evidence. I wonder who's going to be believed. Then we have some messages. Says, you just picked up my call, but not sure you meant to. You just picked up, oh, okay, that's another one. I messaged my doctor and already got a response. You promised that you would be supportive once I sent you what you asked for, and this is above and beyond, so can you please take back what you said and move forward? Not asking you to act like nothing bad has happened, but I sure don't need the silent treatment right now with all that's going on. We need to try to be teammates. So I'm wondering, if one is the sent message and one is the received message. Or what? I don't know how to read this. But I wonder if that's what it is. But the teammates one is sent. So I sent it 28. It was received at 30. I'll be a better teammate. Thank you. Thank you. How's your day going? How's your day going? Just coming back to the city for the birthday now. And then it has that picture, those two pictures. Oh no, okay, those were sent at 28. And then that was sent at 30. 32, 32, 32, 13. Okay. All right, so those are the extra exhibits that he put in the addendum. That's where we are going to end this video. That is the end of the document and what Gingras has to say. Those thus far are his last words before trial on Monday. I will be going over what happens. I will be watching, and then I will cover my key points and things that I want to talk about myself. If you like this video and want to see my opinions on the rest of this case, I am going to finish up with Gillespie, but it is going to be probably Monday and Tuesday when I get to finish up with Gillespie. I wanted it to make it all before Monday, but that just didn't work out for me. So I made sure I finished all of Owen's stuff, because that's what happens on Monday. So we have all the information going forward, and then we can still continue with Gillespie because he still deserves justice even after what happens with Clayton. So with saying that, hit that like button, subscribe, turn those notifications bells on, and I want you to seek the truth, tell the truth, and live in truth. Not your truth, not somebody else's truth, the truth, the absolute truth. There is only one truth. And if you seek the truth and justice and real answers, and you tell the truth, you don't have to remember lies that you've come up with, stories and such. You just live how you live. And then if you live in the truth, things are just what they are. You don't have to embellish things. You don't have to do anything. You just have everything as it is, and it will be enough. Your truth, not your truth, but living in the truth and telling the truth is enough. You don't have to do more to get people to believe you. Keep being honest. And I will see y'all next time.